veterans out there know this is not an impossible deal here. I mean, if you can't work, regardless of what your level of rating is, you stand, I think, a decent shot with the right narrative, with the right evidence put together.
Yep. And almost every extra scheduler case, I always get a vocational report.
Exactly right. Let me ask you just about vocational assessments. Is it a good idea for a veteran to get one before he applies, or is it something you might use on an appeal if you lost?
I always wait to get it. My philosophy is make the claim, see if you get lucky with a C&P examiner and VA grants it. Then you haven't wasted money on a vocational report when it was going to be granted anyway.
Don't get any of these. In matter of fact, just the normal nexus opinion or a vocational assessment, I would never get any of that up front, right? Because
exactly.
As long as you have the evidence and the possibility of convincing that examiner that what you say is so, then you stand a good shot at winning the claim outright.
And the other thing coming in with your vocational expert later is they'll be able to rebut a negative VA opinion.
Exactly.
As opposed to you filing your vocational report and then it's the VA examiner trying to poke holes in your vocational report. You'll get the last word by waiting.
Always the most important thing when it comes to arguing your case, last words. But there's other evidence, job descriptions from employers, current medical documentation. The veteran might be going to physical therapy or whatnot. And he might have some other description in his records about problems he's having with different standing or sitting or whatever it might be. And then, of course, there's Social Security determinations. A lot of veterans have already got Social Security disability. Those determinations may, in fact, be helpful. Actually, if a veteran has Social Security disability, the VA is going to get those records anyway, right? So even if there's something that may not be favorable to the claim, for example, other disabilities that aren't service connected, but tell me how that determination might help or hurt.
Sure. So VA is not bound by Social Security's determination, but it's obviously persuasive evidence if Social Security found you can't work due to your service-connected PTSD. One of the issues with Social Security determinations, as you alluded to, is when the Social Security grant is based on service-connected and non-service connected disabilities. Oftentimes VA, they'll say, yes, you were granted Social Security. However, it was a grant based on non-service connected conditions. We can only grant TDIU if you can't work due to your service connected conditions, and they deny it. And then you have to explain to VA that it doesn't matter what Social Security did. It can be that if the veteran can't work due to this combination of service connected and non-service connected disabilities, but also at the same time, he or she can't work strictly due to his or her service-connected disabilities.
Right. So there's an argument for both that might need to be made, right? When it finally, the final result is going to come in, right? So here's a case from this year, 2023, that I found really interesting. I probably reviewed 2,000 or 3,000 of these to make this video, and I didn't find a single time where there was a favorable termination by the director of compensation, right? This is almost what it always says: denied entitlement to extra-schedular TDIU, right? I mean, so it's kind of funny because this is like the perfect case for a regional office to just say yes, regardless of what the compensation determination made. And that brings up a question: is the regional office bound by that determination? Can they still look at the facts? Right, like here, it was just so simple. The veteran's, rated for a condition that affects his work. The VA examiner said it affects his work, and the Social Security specifically said it was a major factor in him not working. The sarcoidosis here, breathing issue, right? So all of it was there, but it had to go to the board, which seems a little silly, doesn't it?
It does. I do think the RO is bound. I don't know that it's laid out in the statute, but the director of compensation and, in the hierarchy is above the regional office. And if they're saying no,
so
I think
pretty
the
much they say
it's
going to the board.
Yeah. Like I said before, I had a case where the regional office, when they referred it to the director, they recommended the director grant it, and the director did not. And then the regional office denied it.
Yeah. So that's kind of a little, just because this is just black and white, right?
Right.
and this particular
and Social Security's granted it. Yeah.
The board didn't hesitate, although I'm not a giant fan of the board. when you compare it to the regional office, I mean, there's a huge difference, right? So,
huge. And this, it goes to show you can win extra scheduler TDIU. It's just going to take longer. You have to jump through the director compensation hoop, and then you're going to have to go to the board in almost every case. But actually winning it, it's very, very possible.
Yeah, I mean, I was just really surprised to see how often it happened. But anyway, so veterans out there know this is not an impossible deal here. I mean, if you can't work, regardless of what your level of rating is, you stand, I think, a decent shot with the right narrative, with the right evidence put together.
Yep. And almost every extra scheduler case, I always get a vocational report.
Exactly, right. More evidence is always better.
Exactly.
Okay, let's talk about effective dates, right? Here's another big problem when you finally do win your claim, whether it's extra scheduler or otherwise. Now there is a fight over when do you get paid from. And I will admit here that there's a few more explanations how an effective date can work when it comes to TDIU. Basically, when the VA receives a claim, right, date is the date your effective date originates from. But that's just not true. So there's the implicit denial rule. There is, when the scheduler TDIU requirement was met, there's implicitly raised, there's increased dates that can predate your actual claim by up to a year. And then there's informal. So there's a number of factors, right? And, so we're going to go into each one of these a little bit here, veterans. But remember, the facts have to fit here. What I find a lot of time when I look at board decisions is it's really clear that the facts didn't fit the situation, even though they're arguing for these other dates to get the earliest possible pay date. But the facts often just aren't there. It's not always the case. You may not always have a case where it can go back. So don't always believe you have more coming. Again, it's the facts that dictate. And so let's go into some of those. I use this particular case just because they phrased it so well in this one little paragraph about how disability works. Why don't you read that for us?
Sure. So in Ingram, the court held that the award of a disability rating less than 100% generally provides notice as to how the secretary has rated a claimant's condition and serves as a final decision, if unappealed, with regard to entitlement to any higher disability rating associated with the underlying disability, including TDIU. Basically, what that means, it's a way for VA to deny TDIU without actually denying TDIU or letting you know that they're denying TDIU. So
that just sounds so crazy, right? So
it's terrible.
If they told me, for example, I'm that guitar player and my left hand, that particular condition, whatever decision they made on it is in fact also a decision about unemployability. That just sounds crazy.
I agree, and I think it is, and it's
but that's
as
the rule.
We see on it's not really the rule. It's an unsettled area of law.
I would agree with that, but let me tell you, when I went through these 3,000 claims or so, right, I found this case or elements of this case in 3/4 of those decisions, right? It just came up so often that the board certainly calls it out a lot. So
yeah, well, the board unfortunately is not right all the time.
I completely
as you'll see
agree
in the
with
next
that.
slide.
As I've had case go to the federal court, which I beat them on, right? So the board was like stupidly wrong in my case. But anyway, there's some other information about the implicit denial. Could you go over that?
Yeah, so this is a case that I have been working on it for almost 10 years. And I'll read through these bullet points, but it talks about Ingram and whether the award of a rating less than 100% can implicitly deny an implicit TDIU claim. And you'll see here in the first bullet point, the court wrote, the board was incorrect in concluding that the issuance of a scheduler rating less than 100% automatically extinguishes an implicitly raised TDIU claim. And so Mr. Borelli, Vietnam veteran, 2004, he had prostate cancer. He had a prostatectomy. Afterwards, he had urinary incontinence. He made his claim for service connection. And on some correspondence, he wrote to the VA that he had to retire in part due to his urinary incontinence. VA adjudicated his claim and they awarded an initial rating of 40% for residuals of prostate cancer. Nothing happened to his claim until he contacted me in 2014, 2015. and we applied for TDIU based on his urinary incontinence. We won that. The VA only awarded it back to 2014 when we applied for it. And so we appealed the effective date, and we argued that his statement in 2004 that he wrote to VA saying he had retired early due to urinary incontinence was an implicit claim for TDIU, meaning the issue of TDIU was just raised by the record and created a claim itself. He didn't have to claim TDIU. And thus, since TDIU was granted, it should go back to the date of the claim, which was 2004. And the board denied it based on Ingram. They said, well, the regional office gave him a 40% rating, and that should have put Mr. Borelli on notice that they were also denying TDIU. Even though the rating decision doesn't talk about TDIU at all, Mr. Borelli, as most veterans, had no idea what TDIU even was. And so we appealed the board's decision up to the court, and Judge Toth wrote this great decision. And he explained that VA can only implicitly deny an implicit TDIU claim if the rating decision discusses TDIU in a manner that is sufficient to put the claimant on notice that it was being considered and rejected. And so he basically said, no, the award of less than 100% does not deny TDIU. The rating decision has to talk about TDIU in order for it to be denied. And so the court reversed the board, and on remand, the board granted the earlier effective date.
Wow. Sadly, that's not a case that, all right, I can't even pronounce the word.
It's not precedential.
It's
correct.
Not
it's a single judge decision. And I've lost other single judge decisions at the court. Judge Lauer recently denied and agreed with the board that a rating of less than 100% can deny TDIU. But you should try, because the judges are split on this issue. I expect it will eventually come up to the federal circuit and we'll get a direct answer. But this decision is good to read. Judge Toth explained why he believed Ingram doesn't apply. You can type in those docket numbers.
I think it's a stupid rule, right?
Sure.
But like you explained earlier, most veterans have no idea even what it is before you know what it is, right? I just find it crazy that they even have such a rule.
I agree.
What do we do, right?
The point of an implicit TDIU claim is to create this claim on its own and make VA adjudicate, because most veterans don't know about it. And so if that's the reason for implicit TDIU claims, how can you then say you can implicitly deny them without even discussing the benefit?
Yeah, their logic sometimes is like crazy, right? There's a possibility here that an argument can be put forth to overcome that implicit denial rule. What I find at the board and at the federal court level is it really depends on the guy you get sitting at the bench, right? He can make a determination that may be surprising to other people. So
it does. And this is why, when you appeal something, you want to do legal argument. If you're appealing, an implicit TDIU claim, earlier effective date, you want to cite Borelli. And you can tell the board, this is a non-presidential decision, but look what Judge Toth found.
No, I completely agree. And that's when there's a lot of money on the line. What I have always recommended to veterans is don't listen to me. Go get a lawyer, right? Because it's too important of an argument to lose, right?
It is.
I tell veterans often that 70% of something better than 100% of nothing, right? So when money's on the line, years worth of money, right? 5, 6 figures, right? It's time to, in my opinion, to bring on a professional. So anyway, let's move on from that. And here's like an example of a TDIU requirement met.
Yeah. So we can just go through these, but January 2022 files a claim for depression. Depression's granted at 70%, back to the effective date, or back to the date the claim was made in January. And then right after, they file a claim for TDIU, and that's granted. And so that should go back to January 2022. One thing I recommend doing in these type of situations, if you just win service connection and an initial rating for a condition, to make clear that you've continually prosecuted that claim, I always file a supplemental claim. And so in this situation, I would file a supplemental claim and say the veteran is disagreeing with the 70% rating for depression and instead requests TDIU, because TDIU is a rating, as we spoke about earlier. It's a rating. And so you're disagreeing with the 70% and arguing that should be TDIU. I have a colleague who is in this type of situation, where they didn't do a supplemental claim. They just filed a 526 with the TDIU application after they won service connection. And the board treated that as a new claim for increased rating. And so in this situation, the VA is only giving them an effective date back to July. And so for that reason, I always recommend using a supplemental claim form to make clear that you're continuously prosecuting that original claim.
Right. And that's certainly, but even if you didn't, though, I mean, it's pretty clear that it should go back to that rating date where you met the minimum. Matter of fact, I rarely see where it doesn't, at least once the veteran completes all of his paperwork.